Okay. Good evening, everyone. Welcome to another parent education workshop presented by Greene Towne Montessori School. This evening, we're talking about estate planning with Maylee Marsano, and I just want to give a quick bio for Maylee. She is a mother of 3 alumni GTMS children that are currently in 7th, 5th, and 2nd grade at Waldron Mercy Academy. She's been on the Greene Towne board for the last 5 years and is a practicing attorney. She's currently a shareholder at Flaster Greenberg PC in its business and corporate department, representing and advising individual clients and families through all aspects of trust and estate planning, with an emphasis on asset and wealth preservation. She has her JD and Masters of Law in Taxation, LLM, from Temple University Beasley School of Law, and lives in Center City. And we welcome you. Thank you so much for coming.
Thank you for having me. I can't believe hearing you say that 7th, 5th, and 2nd grade. I feel like I was on the other side of that, having Greene Towne kids. Just yesterday, as they say. It goes fast. So yes, so estate planning. I am, like Nicole said, at Flaster Greenberg, and I do trust and estates for them. And I do a lot of families and then businesses. We run the gamut of who we service for estate planning. And I think just in the beginning, I'm just talking, so, feel free to ask questions at any point. And Nicole has my contact information. If something comes up afterwards, feel free to email me or call me if there's a specific question you have, or if we don't go into depth about something that's, relevant to you, but that might not be relevant to a lot of people. Please feel free to email me. But I think for estate plans, I think most people think an estate plan is really like, what happens to my stuff, right? Like after I die, what happens to my stuff? What happens to my kids in this situation with the age of the children? But really, it's more holistic than that. It's not just that. There's a lot of parts to your estate plan that really kind of click into place before we die. And so I think that that's one of the things that I just want to address, especially for young families, that it's always good to have an estate plan in place for every part of your life, not just after I die. And also, it's not just for the super wealthy either. Like a lot of people also have the belief that, well, I don't really need an estate plan or an organized plan because I don't have enough of an estate, right? Like I don't have enough commas in my bank account to really warrant me having these documents in place. And so I'd say for those two things, not true, right? Like we all want to have a plan. We should all, as a planner, it makes sense to have something that's there and ready for your loved ones to see, so that they don't have to worry about those questions if something did happen to you, regardless of how much money you have in your bank account. So I would say at the beginning, what happens before we get to the dying part is really important. They're kind of like the unsung, these documents are like the unsung hero of the estate plan. It's a power of attorney and a healthcare power of attorney and living will. So those two documents are really with us while we're alive. They die with us, but you may have come across powers of attorney before, whether you've dealt with things for an aging family member, maybe a parent, or maybe a limited power of attorney you might have signed for like a real estate agent to buy a house for you if you can't make it to closing. Those are all the kinds of documents I'm talking about when it has to do with your finances. So a power of attorney really it allows someone, an agent, to act on your behalf if there's any type of capacity issue. So that's short-term or long-term capacity issue. That's I'm overseas and I can't pay my bills because I'm having a great time on a cruise ship kind of issue. And there's also, I got in a car accident, I'm in a coma for a month and someone can access my bank account. So we're alive and well, the document's alive and well with us, but we've named an agent that can step into our shoes and do all of our financial everything we need to do, pay accounts, pay our bills, all those types of things that it's important to have someone named. And again, it's really important to do it when you're thinking about, well, who would be the best person, not when there's a crisis. So as a married couple, you have kind of the automatic agent in your spouse. A lot of our accounts are joint, so you could probably access those without a power of attorney in place. But for people that aren't married, for people that have the super romantic side-by-side coma, right? We may need a second person. And again, a lot of times at the age of the people, I can't see everybody, but most of the age of the people I'm speaking to, this really could be like, I'm an agent now for my parent. And so do you need to step in and start paying bills for mom or dad? This keeps it very private. You have this in place, you're named already. So that's what that document does. Super powerful, also very powerful because in this digital age, we have a very big digital footprint, which we do a lot of things online now. And so a bank or financial industry may say, I want to see a live power of attorney before I let you have the passwords for mom or dad. Like, I'm not going to let you just do his online banking. So that document is a good document to refresh every few years. Healthcare power of attorney is the second one. Healthcare power of attorney and living will. This is the same type of document, but it's for financial decisions. Again, really important to do when you're alive and well and there's no crisis presented. I have, can have my spouse as my first agent, but who's going to be my second agent, or who's going to be maybe like the committee of people that would, maybe I want all of my siblings, or I want all of my siblings to talk to my adult child. Those are all decisions that you can discuss ahead of time and have it on paper. And it's really just guidance for your loved ones to know, should we do heroic measures? Should we not? Does he want a religious ceremony? Does he not? Like all those questions that nobody really wants to answer. That's usually the smallest document in terms of like weight. There's maybe 3 or 4 pages for this document, but it's the most emotional usually because you have to make end of life decisions for yourself. So first part of that is really just a Hipaa release. There may be doctors on the call, so I don't want to say what I usually say. I usually say the same thing you see at a doctor's office, but you don't read and sign. It's really the same thing. Hipaa release allows your agent to speak to your doctor on your behalf. Again, your spouse probably won't have the same issues as a second in command person would be. If my sister comes in to do these decisions, a doctor may actually look to see if there's a document in place. If it's a spouse, they might not. It really just depends on the doctor and the hospital. But so the first part, this Hipaa release allows the doctor to talk to your agents that you've picked. And then the second portion is where you're making your end of life decisions. So again, super important document every once in a while. And as we age, sometimes you might want to lay eyes on it and decide, is it still my agent that I want? Are these still the people, that I want to make these decisions? And are these still the decisions I would make? So, we make very different decisions at 21 than we do, at the kind of sunset of our life. And I sit down with lots of different ages, and I can tell you they really do change. The decisions that we make about end of life decisions change through the years. So again, depending on what generation, may want to take a look at those documents and just get a refresh every once in a while. All right, so those documents, those are the powers of attorney. Those are the ones that are with us while we're alive. Important not to forget. But then now we move on to, okay, now I've passed away, and it's kind of what we traditionally think of as the estate plan. So that's a will, last will and testament, or a will into a trust. It really depends on how you want your plan to flow, what makes sense to do, or also what state. So I say what state because a lot of times when we talk about trusts, or we talk about any type of like will or testamentary document, right? Like a last will and testament, a testament having to do with now I've passed away, what do I want? A lot of times when we talk about trusts, the reason we're talking about them is because we don't want to have to probate. Like everyone's heard about probate or knew a friend who's had to probate a will and has a very, very bad rap to probate. Pennsylvania, it's not very difficult or very expensive to probate. It really depends on what state you're in. What type of plan is kind of like the automatic plan that you get when you sit down with an estate planner. So I would say that it's probably 50-50 in Pennsylvania if you end up with a trust right away, or if you end up with a trust inside your will. Those are usually the two different kinds of ways you end up touching a trust with your like first or second go around with an estate plan. And I don't want to get like super, crazy into one direction or the other. And I can definitely answer questions if you guys have specific questions about those. But everybody has a will or should have a will, and the will is going to name your executor. And the executor is the person who is really just in charge. It's a very thankless job generally. It's just you're in charge of the closing up of someone's estate, meaning all of their assets, paying final bills, those types of decisions. When we have minor children, what we want to do inside a will or inside of our trust, whatever we decide to do, we want to name a guardian of the person, right? So that's when it comes down to parents, whether you're married or not, if you're co-parenting with someone, that's one of the main decisions you really want to agree on. You don't want to have documents that have different guardians, because that can be an issue, right? Like you name your sister and he names his brother, and then the court has to decide. So I would say of all the agents that you can pick for any of these decisions, right? Like I'm going to pick a power of attorney to help me with my finances. I'm going to pick someone for my end of life living will decisions. And again, this could be the same person over and over again. This could be my best friend for every single role, but it could be very different. It could be a different person for each role. Whoever these agents are I pick, I don't have to pick the same person as my spouse, right? I don't have to pick the same person as anybody. They don't have to pick the same person as me. But if I'm co-parenting with someone, a guardian decision is a good idea to agree. It would most likely go to, if you didn't write anything down, the natural kind of flow of things would be if there's one parent who's still alive, the children would go to that one parent who's still alive, right? If something happens to both of you, you really want to be on the same page. But with minor children, you want to think about guardianship, and then you want to think about, okay, well, this is the person who's going to take charge of my children, custody of my children. And then this is the person who's going to take charge of the finances for my children. Doesn't have to be the same person. It can be the same person, but it doesn't have to be the same person. There's a lot of decision-making that goes into these types of agent decisions. So-and-so good with finances? Are they not? Do I want to check and balance? Do I want to have my sister take the child, but I want someone else to be in charge of the money because I don't want her to like blow it all on something I wouldn't do, right? It really depends. It's all very personal. It's how you view money, and it's also who you're choosing. If you trust the people you're choosing, you may choose them for everything. And, you 100% are totally fine with whatever decision they would make. So usually when you sit down, you realize, okay, there's a very small stable of people in most people's lives that they trust for any of this stuff. And you're going to see the same names over and over and over again if you were to fill out an estate plan. But it's good to start thinking about, well, who are those people and what role could they play in this stuff for me? But so the reason we talk about trust to avoid probate is that anything that's named, it's important to talk about how our assets are held, meaning there's different buckets of assets that we all have. And there's the assets that go through probate. So through a will would direct, and then there are assets that are not probatable. So it's important to understand the difference when we talk about wills and trusts, because we can have a will that says all the things we want it to say, But if my IRA, my 401k, my life insurance, they all have beneficiary forms, right? So my will could say I want everything to go to my children, but my IRA says I want it all to go to my, I don't know, who you would charity. I don't know why you would do it that way, but whoever you, my ex-spouse, right? Like I never changed it, and my IRA still goes to my ex. Doesn't matter what your will says, your IRA beneficiary form is what's gonna rule the day when it comes to your IRA beneficiary form. So IRA, 401k, life insurance, anything that, like back in the day when you would sit down with an HR person when you got a new job and they would say, you have to fill out this form and who's going to be your beneficiary, right? We do all that online now, but none of that stuff is probatable. All of that stuff goes by way of the beneficiary form. So it's always important to make sure your life insurance beneficiary stuff is exactly how you want it to be, to your spouse or to your children directly. Same as an IRA. If you roll it over, don't forget old IRAs at old jobs. Sometimes we leave IRAs at jobs and maybe the beneficiary forms haven't been filled out correctly for like a decade. 401k, again. So those are not probatable. And then anything jointly held. So jointly held real estate with my spouse, jointly held checking account, jointly held mutual funds, jointly held whatever. As long as it has a survivorship designation, that stuff is going to go right to my spouse if I die. Again, it doesn't matter what my will says. So I don't know about you, but most people, especially young married couples, hold the lion's share of their assets not probatable, right? Most of our assets are either jointly held real estate, in our retirement funds, possibly we have life insurance, hopefully we do. If you think about it, okay, it's really almost more important as a married couple for the survivor of you, what your estate plan says, because the first person who dies, the second one, you inherit it all as a surviving spouse. And so it's really important to think about how are my assets titled and how do I want them to flow? So maybe they're not jointly titled and your will is more important. Not everybody holds everything jointly titled. Maybe your business entity is 100% just yours. And so you need to worry about, okay, well, my business is really what the issue is. And so that has to be part of my estate plan. So titling is really important when you think about any of this stuff, because you have to think about how it would flow if something happened to you. Okay, so that's your assets. You kind of understand where it goes and how it gets directed, right? Like either beneficiary form or jointly held. And if it's not, if it's my individual asset, now my will is going to direct it. So the will is important in this instance. If I have things that are individual, or again, if I'm the surviving spouse, or if something happens to both of us, your will is important. So your will direct everything the way you want it to go. So it breaks things down into your tangible personal property, which is things you can touch. So that's, my artwork or my ring from my grandmother or things like that is your tangible personal property. And then it will be residue. They call it residue, which is really everything. It's residue sounds like, oh, it's the leftover, but it's really pretty much my entire estate, right? And so where do I want my residue to go? I want it to go all to my spouse and then my kids. Do I want it to go, however it is? That's a normal plan, right? Like all to my spouse and then to my kids. And I don't want my kids to get it until a certain age. So that's a pretty typical plan for a young family. And then depending on, I don't know how many variations of that there could be, it's like, what age do you want them to get it? You want somebody to be a gatekeeper or a trustee for those funds until they're older. you want to set aside money and be very specific, like they can only get it for XYZ reasons, or they can, get it for whatever they want. You can be very specific, or you can be very general with the terms of your trust. And it depends on if I really trust my trustee and I think he or she is going to do a great job managing my children so that they don't spend it all on a Lamborghini and they actually go to college, then maybe I'm less like worried about what the parameters of the trust are. And I just say, oh, my trustee has discretion. If I'm very worried about, my children and I don't know what the situation will be like, I may put more parameters on it. And then as I age and see how my kids are, maybe I loosen them up through the years. It's hard to know at age 7 what my kid's going to do. If I now have a 25-year-old, I may feel more comfortable with, leaving a trust be a little bit more discretionary. So, importantly, these documents are very flexible. They can age with your children. You can change them, but you want to have a will, and your will can either have this trust embedded inside of it, which would be unfunded, right? It would only be funded if something happened to both of you, and it would have all those terms we talked about, like certain age they can't get it, a trustee's in charge, those types of decisions you can make, and you can embed that inside your will. Or you can have the will and you can pour that will, P-O-U-R, pour over will into a trust that's a standalone trust. Those are really the two types of plans that a young family usually has in Pennsylvania. And then the standalone trust, you would have all of those same terms that you wanted to have embedded inside the trust. You could kind of flesh out all of the things that you are really thinking about in terms of guidance for your trustee on how to spend the money on your children's behalf if something were to happen to both of you. Depending on asset level, you can get into tax planning. A lot of people worry about, well, what about taxes? How do we minimize taxes? Pennsylvania is one of the very few states left in the country that has an inheritance tax. So congratulations living here with all of us. But there's no tax to a spouse. So there's nothing you can do that you need to do for a spouse. There's the state level taxes and there's federal level taxes in terms of estate and gift tax, inheritance tax. Pennsylvania does have this state level inheritance tax. Your children would be impacted by it, but not a spouse. You can leave a spouse $1 or you can leave a spouse $100 million, and there's no Pennsylvania inheritance tax on that transfer. If you have the luxury of the $100 million transfer, you should obviously do more estate tax planning before that first death, because you would want to try to shield some of that money beforehand instead of just giving it all to the spouse like that. But, if you did, in terms of taxes, it's no harm, no foul. It's really when it comes to the children that there's taxes. So that's the state. There's no state estate tax, but there is the inheritance tax. On the federal level, which is every state is subject to this federal tax. Under the Trump administration, the federal estate tax was doubled. So everyone has a little over 12 million to give away free of federal estate tax. So there's not a lot of people that are above that number. It's possible. We deal with a lot of it as well in terms of business proceeds, but just sitting around in your bank account, you can give 12.6 million to anyone you want free of federal estate tax. And so that's times 2 if you're a couple. That's going to sunset out at the end of 2025. And so it'll be about half that at the end of 2025, which, it starts to pull more families into, okay, maybe we should do some tax planning. So we should try to get around the federal estate tax issue. There are ways to minimize the exposure, but again, in terms of tax, it depends on where you are on the asset level, whether or not we need to worry about federal estate taxes or not. If you are exposed to that, or you could be exposed to that, there's definitely ways to minimize your exposure. So that would be more like an advanced tax plan inside your estate plan. But definitely something to keep in mind if there's a lot of life insurance, if there's business proceeds in the next few years, that number is going to lower significantly unless it gets made permanent, which nobody knows, nobody has a crystal ball, but I would be surprised under the Biden administration if it gets made permanent. So, yeah. So, I mean, that's really, the 3 to 4 documents you really need to have. Every few years, you should really put your eyes on them, make sure they're all the same agents that you still want. That's usually the big change, is agents can change, and you might not want the same people anymore. The rule of thumb is 2 to 3 years. Realistically it's 3 to 5 years, or also if there's a major life event. So usually if there's a major life event, that's when you say, oh, let me dust these documents off and like take a look at what it says. Like a parent retires, a parent dies, a child is born, a retirement, new job, any of those types of lost a job, any of that type of thing. Usually you would want to take a look and see whether or not your documents are still how you want them to be. Do they still express your wishes? And also changing of states, if you change states. But I'm happy to answer any questions. I know I just talked at you, but there's not a lot of, if we were in person, I'd probably have a handout or something, but this isn't really like a PowerPoint kind of discussion. But I'm happy to answer any questions you might have, if there are any. I know we were asked some in the beginning that we answered already, so we may questioned out, but.
Nala didn't have a question in the chat. She just sends her best and thanks you for your expertise.
Does anybody on the call have estate plans in place? Because I can tell you, it's one of those things that most people talk about and don't do. So that's another thing, is people are kind of embarrassed to, go in and say like, oh, I've never done one, but it's really something that happens. You would be shocked at how many people in an office full of attorneys with notaries down the hall don't have an estate plan. It's just not something people like to think about. And, or they're like 30 years old, right? Like you might do it and it's like, all my kids have graduated college, Are there restrictions for selecting an agent out of state? No, there's not. Logistically, now it's a lot easier to have somebody who's out of state because a lot of things are online. I would say with living wills, kind of the general idea would be like, who's the person you really would want in charge for that kind of decision? And could you have someone who's local be part of a committee with that person? Just because if there's a hospital you have to go to, it may be difficult for someone on the phone, depending on how far away they are. But a lot of financial power of attorney decisions, executive decisions, those types of financial decisions you can do online now. So it's fine to have someone out of state. Sometimes international people, it can be a little challenging. I can tell you that I've had a few challenges with international agents because it's the craziest reason, but because of notary requirements, because we have different notary requirements than they do in a lot, especially European countries, or well, actually really just about everywhere. And so a lot of times people are required to go to the embassy to get notarized before they can do something financial if they're an out of the country agent. So that can be a hurdle that's really kind of a pain in the neck if you're waiting for, I mean, the reason you're like getting an agent to work for you or to help you is because you need the help, right? Like you don't have to wait around for someone to have to make an appointment at the embassy to go get a special emblem notary. So I can say with the caution that international could be an issue, there's no problem with having somebody out of state.
Thank you.
Does anybody else have any questions they want to ask?
You can tell everyone's face, they're super excited about estate planning.
I feel like I would have more questions going through the process, if that makes sense.
Absolutely.
I feel like it's a lot of info. So
yep,
I
absolutely.
think sitting down, going through it, it's where, probably would have more questions.
Yeah, absolutely. And I think, we could, I mean, if you're interested, I could always send like an outline or something of what each document does. If you want to reach out, I can always send an outline. I think the biggest decisions is usually just who are your agents, and people always feel bad about picking the same person over and over. But it really is who you would pick to do the same stuff. I mean, most people don't have, if I got in a car accident, there's probably like 2 or 3 people I'd call, that's going to be the same kind of stable of people that you trust to do everything. So just makes sense that you would have the same people over and over. I mean, a lot of people will name their parents, and then as their parents age, they have friends or siblings. And then, as everyone else ages, then your child usually slides into that slot. So the documents can be flexible, and you can, grow and change with them and change them as your children age too. The guardians you have when someone is a baby is probably not, or might not be, the same guardian you want when they're in high school. You make different decisions at different points in your life, which is why when there's a major life event or a change of circumstance, or every few years, it's a good idea to just think about it. It's easy for me to say as a planner because this is what I do. And I on this side of things, I say, write it all down so that whoever it is knows this is what you want. And that's really what it is. It just takes the burden. You're taking the burden off those people to make the decisions for you, because you've made it already. You've told them what you want, so they don't have to second guess their own decision making. So I think that's really like I know it's always like, well, who has my money and who did this? But really you're giving them guidance for all of the things that you would want if you were here. So I'm happy to answer any questions you didn't want to ask on the thing too. So just, shoot me an email, or if you have any questions later when you say, oh, I don't remember any of what she said, which she might not, totally fine. It happens. And, happy to go over as much or as little as you want.
Well, if no one else has any questions, Maylee, I want to thank you so much for doing this workshop with us. And as she said, if you want to get in contact with her, you can reach out to her, you can reach out to us, and we'll put you in contact with Maylee, and she can answer your questions. And for everyone who was able to make it tonight, thank you so much for coming to the talk. And if you're watching this later, thank you so much for watching. And I want everyone to have a great night. Thank you so much. Thanks again, Maylee.
Thank you.
Good night, everybody.